Welcome to Panko Collaborative Law and Mediation and this short presentation of some things for you to put your mind to when you are preparing your estate documents. We're going to talk about your last will and testament, your power of attorney document, and your healthcare directive. Now, please keep in mind as you're watching this video that there may be things that raise additional questions for you, and it will be important to have independent legal advice. These questions, however, are a great starting point when you are putting your mind to these documents and thinking about what instructions you will be giving to your lawyer in preparing the documents. So let's talk about your last will and testament first. The first question to answer is, who do you want to have in charge of your estate? That person is called the executor. You can name more than one person to be your executor, and if you do, you'll want to decide if you would require all your executors to sign off on any decisions that are made, or would you allow them to operate on what we call a joint and several basis. That allows one executor to make a decision and put the necessary documents in place without requiring the signatures of the other executor or executors. If you decide to only name one person as your executor, it's important to have an alternate named in the event that your first choice has predeceased you or is otherwise unable or unwilling to perform the duties of being your executor. If you have special gifts that you would like to leave, that's the next thing to tell your lawyer about. Now, that might be having a special gift to a charitable organization, for example, a dollar amount or a percentage value of your estate. Sometimes you might have a piece of property, an item that you'd like to leave to a specific person. That is something else that can be included in your will. And everything that's left over after all the bills have been paid and these special gifts have been distributed is what's called the residue of your estate. Sometimes somebody would like to just leave the residue to one surviving person. It might be their spouse, for example. In another instance, you might have more than one person that you would like to share that residue with. That might be by percentage of sharing of the estate, or it might be certain dollar amounts. Now, if one of your beneficiaries is to die, you would like to decide, it's important to decide if you would like their gift to be given to their surviving children, if they have surviving children, their surviving grandchildren, if their children had passed away, and so on. That's what we call on per stirrupes basis. So basically, it's just following the bloodline. You may not wish that to happen, and instead your beneficiary who has died before receiving their gift, that gift then would just go back into the residue to be shared with the remaining beneficiaries, the surviving beneficiaries. All right, now, if you have minor children, you also want to put your mind to provisions for those children. Who would you have take care of them and manage their gift that you've left in the will for them, their inheritance? It's not just minor children, though. You might also be responsible for a dependent adult in your life, and that would be important to put your mind to that as well. Any of the funds that you leave behind will be managed in a trust, and that person you named will be the trustee. Now, another document to put your mind to is your power of attorney document. Now, this is where you are still alive, but something has happened that makes it so that you are unable to make decisions for yourself and take care of your own property, finances, and your own day-to-day activities. And in this document, you would be naming somebody to take care of you. That person we will call your attorney, not to be confused with your lawyer. Now, you can, the same way as with your will, you can name more than one person to make those decisions for you, and you will want to decide if you are naming more than one person, do they all have to sign off on everything, or would you appoint them on a joint and several basis so that one person can take action in the absence of the other? And just like our executor in the last will and testament, if you have named only one person to have a power power under this power of attorney as your attorney, it's wise to name an alternate in the event that your first choice is unable or unwilling to act. The last thing that you need to think about when appointing a power of attorney is whether you want those powers to become immediately effective, or if you would want to have it be contingent on the signature of one or more medical professionals that say that you have lost your capacity to make decisions. There are pros and cons to both ways of doing it. If it's immediately effective, your person that you've named as the attorney to have these powers is not to use those powers until there's a time when you have lost your mental capacity. But if that time was to ever come, they'd be immediately able to step in with this document, pay your bills, and make any decisions that are needed to be made without delay. Now, on the other hand, if you choose to name your attorney or attorneys on a contingent basis, what that does is it gives you some peace of mind that somebody isn't going to prematurely start making decisions on your behalf simply because they think you've lost your mental capacity. It does create an extra step for the person who is needing to pay bills on your behalf and look after your matters by requiring them to take you to the doctor and have a doctor sign off on the fact that you've lost your mental capacity. However, for some people, that can give them some peace of mind just to know that there's another step that would be required before somebody could come in and start making decisions on your behalf. The healthcare directive is where the medical decisions are such that you aren't able to give instructions. So maybe you've been in a car accident and you're in a medically induced coma, for example, or something else has happened to impact your ability to give instructions to a medical care provider. So naming somebody else who can talk to the medical professionals and give instructions, we call that person your proxy. So the same as with your executor for your will and your attorney and your power of attorney, you want to think about whether you want to name one person or multiple people. Would you give multiple people the authority to make decisions just on their own on a joint and several basis, or would you require everybody to give the same instructions to that medical professional? If you choose to name only one person to be your proxy, it's a good idea to put your mind to who an alternate could be should your first choice be unable to act. Now, in addition to this, your healthcare directive also states what your wishes are should you be only being kept alive by machines. And so please put your mind to whether you would like all heroic measures to be taken, or if you would in essence like the machines to be turned off, and you in that instance would pass away without any further interventions. This can be a very difficult thing to imagine, but it's even more difficult for the people who love you to have to decide in the moment if the doctors were to turn to them and say, what is it that they would want to have happen? So if you put your mind to this now and you include those instructions in your healthcare directive, that can give the people that you've left behind that care about you some peace of mind, because they know that they are giving instructions that are in line with what your wishes are. So in other words, would you like to have what's commonly thought of as a DNR, or do not resuscitate, put in place, machines turned off, or would you like there to be all measures and interventions put in place, even in an instant where the doctors have assessed you as being unable to manage without and continue to live without those interventions? Now that you have had a chance to hear some of the things that we will be looking for instructions from you on in order to draft these documents, you might have some more questions like I mentioned earlier. So please feel free to send those questions to me. My email address is cpanko@commonsenselawyer.com. You might not have questions, but you instead just have the instructions. You can email those instructions to me. We'll prepare draft documents and then arrange for you to come in so we can meet in person, review the documents together, confirm to make sure that all of your instructions have been properly put into these documents, and then you will sign those documents and you will be all set up. We do encourage you to also review your documents on a regular basis, and that's something else that we'll talk to you about to determine the frequency on which you would like to review, as well as discuss what's the best place and the safest place to store these documents. I look forward to receiving your instructions and meeting with you soon.